Another typical litigation issue from a franchisor perspective is the liquidated damage clause that franchisors include in franchise agreements as a replacement for future royalties. So, for example, if you terminate a franchisee 6 years into a franchise relationship and it's a 10-year agreement, franchise agreements frequently contain a clause that provides a formula for future royalties in the form of liquidated damages using a formula of some kind. And those issues relating to liquidated damages are frequently litigated because some courts consider liquidated damages to be a forfeiture, and you have to litigate that issue in order to be able to make that claim, or if you're on the franchisee side, to defend against that claim. On non-competition agreements, the issues that are typically litigated are whether or not the geographical scope of the non-competition provision is reasonable, and whether or not the term, the length of the term of the non-competition provision is valid. And again, this is a state-by-state kind of thing. Some states, again, are very, very strict. For example, California does not allow for the enforcement of non-competes, whereas other states have a lot of litigation on the issue and have come to the conclusion that 2 years is too long and 1 year is okay. And you have to be very careful about the litigation strategy as well as the clause that's drafted into your franchise agreement. And so we put a clause in that allows for savings provision. That is, if, for example, the state of New Mexico allows for a 1-year non-compete limitation, we say that our agreement has 2 years unless the state in which the franchisee is located requires a shorter limitation period, in which case we adhere to that shorter limitation period. Many franchisors do the same thing. On the side of the franchisees, the typical litigation claims that are either breach of contract type claims or claims under the Franchise Sales Act. That is the disclosure requirements. And frequently, you find franchisors may have violated provisions of that law either by not giving disclosure documents at all when it's required, or giving defective disclosure documents, or not giving it in a timely manner. But more often than not, those kinds of claims are for fraud and disclosure violations relating to, for example, earnings claims or financial performance representations that are different than those contained in the franchise disclosure document, or earnings claims or financial performance representations where there were none stated in the franchise disclosure document. And that's one of the most prevalent areas of litigation involving franchisees against franchisors. I've been involved in those cases from both sides, and they can be very, very complex and time-consuming litigations because they involve not only proof that the representation was made, but also falsity of the representation and a detailed analysis of how the franchisee got to those earnings claims or financial performance representations. Similarly, there's been a fair amount of litigation over that item 7 that I discussed before, that is the initial investment that franchisors indicate a franchisee is required to make. And that's one of the reasons that we pay very, very close attention to how that provision of the FDD, item 7, is drafted. Because if, for example, a franchisor indicates it'll cost $50,000 or $100,000 to build out a store, and there's no basis for it, and it's cost my client $300,000 to build out a store, there's going to be a litigation over that issue if my client has a problem in the operation of its business. And to tell just a very quick war story, I represented a franchisee of a gym franchise, group of franchisees in a gym workout facility franchise who were told it would cost $50,000 to open their franchise. And when I took the deposition of the franchisor principal, I asked how that information was obtained, and he said that's from a 1984 yellow sheet of paper that he found in his file someplace that indicated how much it cost him to open up the store in 1984, his first unit in 1984. We were in 2007, so it was a 23-year-old document on a frayed piece of yellow pad. Not exactly a valid representation, particularly when it cost my clients, several times more than that to open. The franchise disclosure law in New York provides for fairly extensive liability for a franchise, or as well, interestingly, its principals and the people who make the misrepresentations or misstatements or violate the law. So Section 691 of the General Business Law allows for a claim to be made, and has to be made within 3 years of the violation, which in disclosure violations is typically 3 years after the franchise agreement was signed. and it allows you to sue not only the franchisor, but the principal operator of the franchisor, or the officer or director or employee who made the representation to the franchisee. And there's joint and several liability, and that can be a very strong tool if you're a franchisee or representing a franchisee, and a very difficult position to be in if you're a franchisor and the principal of a franchisor. The liability is for contract damages or rescission and cancellation of the franchise agreement. Typically, when representing franchisees or defending the claim against franchisors, the franchisee is asking for its entire investment back. That is, the money that they put in the initial investment, the franchise fee, the build-out expense, and the money that they lost in operation of the business. Plus, in some cases, the income they thought they were going to derive from the operation of the business. So I represented a restaurant franchisee, and we were able to recover salary, a year's worth of salary, based on the salary that he had given up to operate this franchise. He was told he was going to make at least that much money. So there's a fairly significant deterrent against franchisors violating the law, and a particularly strong enforcement tool for franchisees, who, by the way, are also entitled to recover attorney's fees under Section 691. So it can be, as I said, a fairly good tool for a franchisee to recover an investment if there's been a violation of the law. The other area of litigation that comes up in franchising is what's referred to as hidden franchises. That is where a business licenses to another business the right to operate under a name, under a trade name. Licensee pays a fee, and the franchisor or the licensor didn't know it was operating as a franchise, or tried to avoid the franchise law by not doing a disclosure. There are claims by the people who buy those rights that the franchisor, that the party who sold it to them is actually a franchisor, and then you get into litigation over the failure to provide disclosure, and usually some other issues come up, including violations of the laws concerning provision of financial performance representations. So hidden franchises is an area of litigation. And of course, then in any commercial contract, there's a lot of litigation over breach of contract. And that can be a failure to provide support to a franchisee, a failure to spend advertising money in the right way, a failure to protect an exclusive territory. There are too many claims to mention that I've seen or brought on behalf of franchisees, but suffice it to say there's a substantial amount of litigation by franchisees, disgruntled and unhappy franchisees, who go against franchisors for breach of contract claims. As I said, the civil remedies that are available are in 691, and the sections that relate to that are sections 683, 684, and 687. If there's a violation of any of those provisions, 683, 684, or 687, which I'll talk about in a moment, franchisee can sue under section 691. 683 is the section that revolves around the disclosure you're supposed to provide. So if a franchisor doesn't provide proper disclosure, the franchisee can be sued under 683 and 691. If the franchisor doesn't obtain the proper exemption under 684, they can be sued under 691. And then 687 is sort of a catch-all fraud provision that's modeled on the securities fraud regulations and any fraudulent conduct, the provision of improper earnings information, the provision of improper investment information, whatever it is brought under that section. As I said before, there's joint and several liability under the franchise disclosure law. I should mention that although the Federal Trade Commission regulates the sale of franchises and is very close in terms of the requirements for disclosure to the New York State law, there is no private right of action under the Federal Trade Commission regulations. So any litigation is not brought in federal court unless there is another basis for jurisdiction, such as diversity or trademark violations or federal questions. But there are no claims under the FTC regs. There are claims under the laws of the other 12 states that regulate the sale of franchises to varying degrees, similar to New York. There are laws, as I said before, relationship laws where claims can be brought, and of course there are common law claims, and there are also what are referred to as the little FTC acts, which are the state unfair trade practices laws. Connecticut has one, New Jersey has one, and so on, that franchisees frequently bring litigation claims under for franchise or improprieties or alleged improprieties. The final issue I want to talk about is there's been a lot of writings on the issue of whether or not arbitration is a good method of dispute resolution in a franchise context. It can be very, very expensive, and the benefits of arbitration, in some people's opinion, are not what they used to be. Arbitrations are getting as expensive as litigation. Arbitrations involve the same motion practice and discovery sometimes as litigation does. And so if you want to avoid those costs, sometimes litigation is a preferred method. Similarly, if you're going to go to arbitration, it's a good idea. If you're going to provide for arbitration, it's a very good idea to provide a very extensive set of procedures that you want the arbitration to follow. I mean, arbitration is in fact a creature of contract, and you can set up whatever structure you want, and I recommend that to people who have arbitration clauses, whether it's allowing for or not allowing for certain types of discovery or time limits or the number of arbitrators or where the arbitration will be, and you can control that. There is also another issue of litigation in franchise cases, and that is the dispute about whether or not arbitration is permissible, even though it's provided for, and that frequently turns on whether the arbitration provisions are alleged to be too one-sided, or the agreement is alleged to be induced by fraud. There's a whole host of litigation on that issue, usually siding in favor of arbitration, but that is a common issue in franchise disputes. That's all that we have for now. I would tell people that my firm again is Einbinder and Dunn. We're located in Manhattan. Our website is ed-lawfirm.com, and if anyone has any questions, they can contact us there, and I appreciate your time. Thank you.